Welcome to the Road to Retirement podcast. My name is Alex Neary, and I will be your host. The goal of our podcast is to introduce you and to bring on local experts on various topics surrounding financial planning, from estate planning to tax planning, everything else that we cover with our clients. We want to make sure we're introducing you to the very best professionals we can. All right, we would like to welcome Chelsea Sinclair to the Road to Retirement podcast. Chelsea, thank you for being here.
Thank you for having me.
Absolutely. We'll dive right in, but before we do, I'd wanted to give you a chance to tell our listeners a little bit about your background, where you went to school, how you got to where you are now, and a little bit about what you and your firm do.
Yeah, so my name is Chelsea Sinclair. I grew up in Greece, New York, so I'm a native around here. And I went to undergrad at St. John Fisher, and I graduated from Albany Law School in 2021 and have been practicing since then. So right now, I'm at a firm, Shum and Warner. We're in Spencerport. We've been open for almost 70 years. It was formerly Kennedy and Shum. There's four attorneys, and we have great legal assistants. Any type of estate planning, business formation, estate administration, elder law, so anything including guardianships, Medicaid. We do all of that and real estate, of course. Especially with the Medicaid, we do the applications and the planning, which kind of rolls into the estate planning that we're going to talk about today.
Okay, great. Thank you for that. We get a lot of questions from clients about estate planning topics, whether it's how a will works, power of attorney, different types of trusts. And it's one of those areas where I guess I know a little bit about it, but I feel like I know just enough to be dangerous. So I love to have professionals in my network like yourself that I can lean on to either bounce questions off of, or sometimes I can send clients directly to you or somebody like you to get their questions answered from a professional that really knows that area of expertise. So to
Mhm.
jump into the questions that we get all the time from clients is, do I need a will? Now we work with clients with all kinds of situations, whether they're a young family getting started or maybe they're in their retirement years. Right off the surface with no other criteria, if somebody asks you, Chelsea, do I need a will? What's your best answer?
My generic answer is going to be yes,
Of course.
because the best way that I can put it into perspective is you have a will already, and either you can dictate what it says or New York State will dictate what it says. So you may as well be the one who is putting your wishes down on paper. You know your family dynamic better than New York State will. So you will just have your wishes honored as you would want them to be. Having a will, you know that you are covered and that your family is covered as well.
Okay. So what happens
Mhm.
doomsday scenario or something similar to that? Let's say I'm working with a couple, they're both 65 years old, they've got adult children, they've got a house, they've got 401ks, IRAs, other investments, whatever it might be, and they do not have a will. If
Mhm.
they tragically get hit by a bus, what happens and what happens to their estate?
Yeah, so in that situation, it's called intestacy in New York, and they have a distribution order based on your family tree. So with no will, no beneficiaries, this is where the state will takes over. First, it would go to a spouse if it was just a spouse and no children. But if there's children, then the spouse gets the first 50,000 and next one third, and the rest goes to the children. In this situation, with two spouses who tragically pass away together, their assets would go to their children. And that is only if those are their biological children too, which is an important thing to know and kind of a nuance because every family has different dynamics and it doesn't always line up with the legal definition. So, stepchildren are not treated as biological children, whereas adopted children are. So, a lot of times people may not think about their stepchildren being included because they just are their children, and that's how it is. But unfortunately, in the law, to protect that type of dynamic, you want to make sure you have that written down so that they are covered. Let's say that they didn't have any adult children and the couple passed away. Their estate would actually go to their parents, and from there, it would go to siblings, nieces and nephews, grandparents, aunts and uncles, first cousins, and first cousins once removed. So some people have good records of their family, some people don't. So that is something that an issue you can avoid with a will, stating who is who and who you want to get what.
Are there other considerations for sort of the non-traditional family? So if you have adopted children, or if you sort of have that Brady Bunch situation where there's stepkids from each marriage, are there other things that those people should be thinking about outside of what you just mentioned?
Like I said, just noting in the will, these are my biological children. This is my stepchild. They'll all be considered my children as if they're biological, and then go from there. Another consideration, though, is divorce. They have your spouse is automatically disinherited from the will, but if their will doesn't change and you pass away first, it could get kind of messy where your wishes aren't being totally fulfilled because the estate planning didn't match up, or sometimes people don't always go through fully with the divorce as they think, and then their spouse is entitled to everything. On the other side of that, without the marriage or divorce, a lot of states and people recognize themselves as domestic partners. New York is not one of the states that recognize domestic partners. So you can have a couple that's been together for 40 years. They've lived in the same house. They share everything. They are essentially married in the traditional sense, but legally, if that partner isn't considered a spouse and isn't put into a will, they're left with nothing. And sometimes it can lead to really devastating consequences, especially with houses and if the name's not on the deed, certain things like that. So, definitely, your family dynamic is an important thing to bring up when considering the estate planning that you're doing.
Okay, very good. So it sounds like we should have a will.
Yes, absolutely.
We talked about maybe somebody that's at that retirement stage, or somebody's got adult children, or in a later phase of their life, definitely needing a will. We get the question a lot of times from young families too. So let's say we're in our 20s or 30s, we've got maybe a child at home. Does that kind of person need to also have a will? Because a lot of times we get the one off joke of, well, I don't have any money anyways, oftentimes from somebody that's starting their career and they don't feel like there's much to leave behind.
Right. Exactly, and I definitely hear that all the time too. Any age, if you are over 18, you should really consider having a will, especially if you are starting a career, you're getting married, you're starting a family, because you're not only dictating who gets what, but you're also can dictate who's taking care of your children. If you have minor children when you pass away, New York has a statute that it's put into a trust until they're 18, but of course, when drafting the will, you can change it to whatever age you like, but you also get to choose who is managing that money. It's used typically for the health, maintenance, and welfare of that minor. Those are definitely important things to think about of who you would want to take care of your child, who you want managing the money, if it's the same person or not. So, definitely that is something to consider.
Okay. The next thing that we kind of talked about is just what happens to my money if I die? And this is a question that we get a lot of times. And I think it's important to point out that regardless of what you've done with your will, having the correctly named beneficiaries on each account is a big deal. So whether it's a life insurance policy or your 401k at work or an IRA, Roth IRA, whatever it is, the named beneficiary on the account is, you can correct me if I'm wrong, but that's the number one thing that we're going to look at when someone passes away.
That's correct.
I'm sure you've seen some horror stories with that.
Absolutely. So, as we just spoke about the importance of having a will and why everyone should have one, the whole goal of doing proper estate planning is that you won't even have to enter your will into probate. It's really, you want to use it more of a safety net and be more proactive with some of those financial accounts, all of the financial accounts that you have. So, the main ones, checking and savings accounts at banks. You want to make sure that you go in, you can either have a joint owner on it, or you can list essentially beneficiaries. It's called payable on death. It's a form that you can fill out right at the bank. And what that means is upon your passing, whoever you listed would just have to go to the bank, show your death certificate, and they would be able to get the proceeds from that account. And why that's important is because if you do not have any beneficiaries on the account, it's all part of your estate. So when you pass away, your estate is made up of anything that's held in your name alone. So that does not include joint accounts, accounts with beneficiaries on it, which is really important because if you do not have the beneficiaries, it is part of your estate, then you have to go to probate court, which the court here does a great job, but it will save you a lot in court fees, attorney fees, and time because once you enter your will to probate for the court for your executor to be able to manage any assets, you have to wait 7 months before any of those assets can even be distributed. So that can really make it difficult on family having to wait that amount of time. So going back to having the beneficiaries on, that's an automatic thing. There is no court fees, attorney fees, and it happens automatically. There is no 7-month waiting period. The only other thing I would say about that is not only having you can check with your financial advisor, you can just make sure you have those beneficiaries on, but make sure you don't just have a primary. You also want to have contingent names listed on those accounts in case anything does happen to the primary beneficiary.
Absolutely. We talk a lot about that, making sure that you have the correct beneficiary and also the what if we're both not here, then where does the money go and who's responsible for all that? To sort of segue to our next topic here, another question that we get all the time is about long-term care or long-term care insurance. To kind of set the
Mhm.
stage for that a little bit here in New York State, I think the average cost in a nursing home on a monthly basis is about 15,000 now. And you can imagine with
Mhm.
inflation, that's only going to increase into the future. So it's a major financial pitfall that people run into is how am I going to pay for this? And if I do have the assets to pay for it, do I want the nursing home to take my home, spend down my accounts, and effectively leave my kids with nothing? Most people, when they start out saving for retirement, their goal is not to leave money to their kids, but given the choice between giving money to their children or giving money to a nursing facility, you can imagine what people would prefer. So, what are the options out there as you see it, as how people can protect their assets, and what can we do from here?
Yeah, so the main thing would be to talk with someone early, have a comprehensive list and idea of what all of your assets are and the values of them now. You also want to take into account what your future looks like. If you're in a home right now that you want to stay in forever, or if you're thinking about moving around in 5 to 10 years. What happens with Medicaid is someone has to go to a skilled nursing facility. It's not safe for them to get the care at home anymore. So, like you said, it's very expensive. There's a program called Medicaid where an individual can have up to $30,000 in assets in their name and then they'll be eligible for Medicaid in simple terms. So once you're eligible and get approved for Medicaid, they'll actually cover all of the skilled nursing costs, medicines. They'll also go back 3 months from the date of the application to reimburse any cost of care, anything like that. So the catch there is that one, you have to be eligible. The biggest thing is that I see are people's homes that they want to protect. And typically that is going to put them over the $30,000 limit. When that happens, there's a common misconception that Medicaid will come foreclose on your home and take it from you. They won't do that, but they will put a lien on the property that will be in the amount of the money expended on that person's care in the nursing home. You have to pay that off to sell the house, so they don't necessarily take it, but they do put a lien on the house. So that is the main one that we want to protect. One revocable trust. So what that does is essentially you relinquish control of your property to this trust. It has its own taxpayer identification number. We deed the property into the trust, but we reserve you life use so that you can keep any tax exemptions on the property and you still are responsible for maintaining the property, paying the bills, things like that. So It really changes on paper, but the ownership feel does not change. So, after 5 years of the property being in the trust, it is off the table for Medicaid to look at to consider as an asset, and then they can no longer put a lien on it. And that 5-year period applies to any financials that you have. So it's 5 years from the date of application. They go through every bank statement, IRA, everything, any investment accounts to see if anything has been moved. Essentially, they're looking to ensure that no one's hiding their money to make it look like they are eligible for Medicaid. So that's where the planning early comes in, where you can start to put protections on those assets now so that you don't have to worry about that 5-year look back period.
Okay, very good. And how do retirement assets play into that? So obviously, I know that you can't just take your IRA and put it into someone else's
Mhm.
name and leave it there for 5 years. So, is there a way to protect your retirement assets? If I've got $2 million in an IRA, is that just fair game to pay for healthcare, or is there something else I can do?
So they won't count it towards the asset limit of the $30,000, but they make you put it into the required minimum distribution, make sure it's actuarially sound, and then they count it as your income. So you receive those monthly payments. The person in the nursing home receives those monthly payments. However, they're only allowed to keep a certain amount based on what their income is. If there's a spouse with income, they can keep usually about $50 and the rest would go to the nursing home for their care. Because they're paying it down, it kind of pays it down slowly. Like you said, you don't just have to cash it out right away. They just consider that as income. We typically don't advise putting investment accounts, money, like cash, anything into the irrevocable trust because you have to maintain that property in there. If you put a house in there, it has to stay in there. Or if you buy a new house, it has to go into the trust and be of the same value. Money accounts can be unpredictable. They can lose value. That could break the trust and cause issues. And also, the asset's not available to you during your lifetime. So, if there's money that you wanted to put into a savings account and put into the trust, that you know you won't need that cash in your lifetime, you want it to go to your kids or grandkids, we could do that, but with the IRAs and things, that stays in your name. Again, making sure there's beneficiaries on there and it goes towards the income, so you don't have to worry about pulling that out right away.
Okay, great. And I think a lot of the questions that we hear as financial advisors are kind of the same questions over and over again. Do you feel there's something else out there that maybe clients don't even know to ask? In a lot of ways, you don't know what you don't know. So,
Mhm.
what's the thing that's out there that people should consider about estate planning that maybe they're not even thinking about?
Honestly, one of the biggest miscommunications that I hear is having to do with Medicaid, and they're gonna come evict me and take my house, but like I said, they won't do that. When it comes to estate planning, you definitely just wanna bring as much information as you can about your situation, whether it is your finances, your family dynamic is very important because everyone has different definitions for who is who in their family. And unfortunately, we have to work through and match up to the legal definitions of that, making sure that the judge will approve everything if it goes to probate. So, really just bringing in as much information as you can. Another misconception would be not necessarily thinking of every possibility of, well, I just wanted to go to my spouse and my kids. If you all go on a family vacation, God forbid something happens, now what do you want to happen to this? And just kind of taking that into account. If they need any kind of special trustee to look over that, if they are on any kind of government assistance, we wanna make sure that their shares put into a trust or some type of tool that it's not going to affect any government assistance for the client's children someday. It's not typical to think about, but it's good to look at the whole family situation and who has what going on. I'm not sure if you could speak to this a little bit, but I have heard one story where you can sit down and take a look if depending on, of course, the situation. I haven't personally dealt with this type of situation, but each child is in their own tax bracket, and then they're trying to figure out who to put as beneficiary on each. But their advisor took a look at the tax brackets. They wanted it to be equal, and on paper, it didn't look equal, but because of the taxes that they had to pay, kind of an interesting aspect too of how if financial planner, CPA can really work into helping with the estate planning process.
Yeah, that's a common scenario. So to make kind of as simple of an example as possible, let's say a married couple has two adult children. One is a surgeon that makes $400,000 a year, and the other is, well, use the term loosely, a starving artist, whatever that might mean. And you have two kids that have very different financial situations. So one strategy, if you're talking to your daughter who's a surgeon, is she would rather inherit money that is after tax, meaning that money you have in your 401k or your pre-tax IRA. If she were to inherit it, she would have 10 years to spend it down, and she'd likely be spending it down in the highest tax bracket. So she's losing 37% right off the top to the federal tax, plus state tax here in your state or wherever you might be listening to this. Whereas the starving artist child, we'll say daughter number two, probably doesn't have a lot of income for them to inherit a pre-tax account isn't nearly as big of a deal because they might be able to take distributions at 12% or 22%, much less. So what Chelsea's talking about doing is rather than just taking all of your accounts and dividing them 50-50 between your two children, maybe it makes more sense to, again, on paper, it's going to look like one child's getting more money than the other, but factoring in the tax brackets so that after each child pays taxes, and they take money out of that account, then they're taking home an equal amount of money that they can actually spend and do on things. It is much more complicated to look at it that way because you have tax brackets that are continuing to change. You have those adult children having changes in their careers that are changing their tax brackets as well. But it's certainly something to think about if you do have, again, like a lot of people, kids doing different things in different situations. And if you want to try to make things as even as possible, or if you just won't want somebody to inherit money that does more harm than good in their financial lives.
Absolutely, yeah, it's great to take a look at every aspect of the more holistic picture. I think that your attorney has, your financial planner has the best outcome you're gonna have for the client's goals.
Absolutely. So we've covered a lot today. I guess the one last thing, what I see most often, it's not unusual that I meet with a client and I routinely ask them, do you have a will in place? And I might look at my notes from a year ago, the last time we talked, and see that I asked them that same question, do you have a will in place? And they said, oh, no, I got to do that. Or I've been meaning to do that. And there was just a continuous procrastination around that topic. What is the first step, and like how do you make it as easy as possible for your clients just to get done what they need to without feeling like it's an overwhelming process or something they need to kick down the road?
Yeah, so I also see that a lot. A lot of people coming in because they've seen it can be messy without having any of this, or parents finally come in because their kids have been on them to come in and do their estate planning. But I would say that one of the things to think about with that is really everyone needs one. Putting it into perspective, like I said, either you or New York make your will, you decide. But also try to explain that your family's going to be in a difficult spot if something does happen. And as uncomfortable as it is to maybe talk about now, it saves your kids, your family down the road if something happens to your spouse, God forbid. You know that you are covered, you have a plan in place. A lot of times, people come in and then they'll even say, "Oh, that was a lot easier than I thought. That was not painful." Because I'm we like I said, we get the holistic picture, and I'm not looking through every single bank statement, account numbers, things like that, but taking a look at what they have, asking them what their goals are, and then can turn out legally what would have to be done for that. So I think having as normal, casual as a conversation as you can have about it with the client really helps because you can get a better idea of what they want. They're not aware of all the legal terms and the crazy Latin that has to go into wills. So I view it as my job to take in what they want in their own words, try to reiterate what the goals are, and then make sure that will is legally stating what they want.
Okay, great. If somebody wants to get a hold of you and get their will done tomorrow, how do they do that?
I'm an associate attorney at Shum Warner. We are in Spencerport. My phone number is 585-352-0700. Please feel free to call the office. We can do a consultation. We have no charge for consultations, but even if you have questions, important to find the right fit, and I would be happy to talk to you about it.
All right, very good. Chelsea, thank you for your time today. Very informative, and we appreciate your time.
All right. Thank you so much for having me, Alex.
Content here is for illustrative purposes and general information only. It is not legal, tax, or individualized financial advice, nor is it a recommendation to buy, sell, or hold any specific security or engage in any specific trading strategy. Results will vary. Past performance is no indication of future results or success. Market conditions change continuously. This commentary reflects the personal opinions, viewpoints, and analyses of Alexander Neri. It does not necessarily represent those of RFG Advisory, their clients, or their employees. This commentary should not be regarded as a description of advisory services provided by Alexander Neri or RFG Advisory or performance returns of any client. The views reflected in the commentary are subject to change at any time without notice. Advisory services offered by investment advisory representatives of RFG Advisory, a registered investment advisor. Alexander Neri and RFG Advisory are unaffiliated entities. Advisory services are only offered to clients or prospective clients where RFG Advisory and its representatives are properly licensed or exempt from licensure. No advisory services may be rendered by RFG Advisory unless a client agreement is in place.